Palm Island is an Aboriginal community near Townsville in North Queensland. On the 19th of November 2004, a man referred to in court as Mulrunji was detained by police for being drunk in public. He was transported to the Palm Island police station, and while being removed from the van, he punched one of the officers, Chris Hurley. Hurley dragged Mulrunji into the police station, and the two of them fell together onto the floor. During the fall, Mulrunji sustained very serious injuries, including a severe laceration of his liver, leading to heavy internal bleeding in his abdomen. He died very soon afterwards. The death led to a period of social unrest, which in turn led to an increased and aggressive police presence, which led to more social unrest. It was a mess. The Deputy State Coroner conducted an inquest in which she found that during the process of moving Mulrunji into the police station, Officer Hurley had punched him at least 3 times, and that these punches had caused the wounds from which Mulrunji died. Hurley was later tried for manslaughter and acquitted. Following the criminal trial, Hurley's lawyers sought to have the coroner's decision that he had punched Mulrunji and caused his death overturned. In the Queensland Court of Appeal, their honours set out the test which must be applied if a court is asked to overturn the findings of a coroner. They said, Section 55D of the Act permits the District Court to set aside a finding by a coroner only if satisfied that the finding could not be reasonably supported by the evidence. In the application of this test, the circumstance that the evidence reasonably supported possible findings different from those made by the coroner would not warrant the setting aside of the finding made by the coroner if that finding too was reasonably supported by the evidence. As a result, from this case we learn that when a court is reviewing the findings of a coroner, the sole purpose of the court is to consider whether the finding could reasonably be supported by the evidence. It is not the role of the court to consider other possible findings or to make observations about those. The court ordered a new inquest by a different coroner, which ultimately made an open finding, being unable to say whether the fall and the harm had been accidental or deliberate.